Good day, everyone. This is episode 16 of our channel. So, in this episode, we will discuss the case of CICL XXX versus People, a 2023 En Banc case, GR number 238798, decided by the court last March 14, 2023, and it was penned by Justice Zalameda. So, this case discussed discernment. Okay, so if you are reviewing for the bar or you are a freshman and you want a case that will guide you with regard to discernment, you must know this case. This is relevant in determining the criminal liability of those minors above 15 but below 18. Diba? That when they committed a crime, they may be liable if they acted with discernment. That's why in this case, the involved here is a CICL. Okay, so here the CICL was charged with homicide, and the conflict began on October 27, 2003, when the victim AAA testified against the 17-year-old CICL during a barangay dispute hearing in Baguio City, no, confirming that he had seen the CICL hit another individual with a bucket at a local bar. So at around 3 o'clock the following morning, in the morning, 3 a.m. in the morning, the victim's mother was awakened by shouts of Mama, Mama outside their home in La Trinidad, Benguet. Upon investigating, the parents found AAA lying bloodied at their front gate, and while receiving immediate assistance from his parents, AAA spontaneously explained that CICL XXX and a companion had entered their house claiming to look for someone before si ICL XXX struck AAA in the eyes. No? So sa mata. The victim's medical condition rapidly deteriorated. Admitted to the hospital days later, CT scans revealed massive cerebral contusions and severe brain bleeding. So matindi, no? Yung ginawa sa kanya ng CICL. For losing his ability to speak, AAA once again identified CICL XXX as his attacker to his sister. So, kinausap yung kapatid niya, sinabi niya it was a CICL XXX who did that sa kanya. AAA was eventually discharged in a bedridden vegetative state, where he remained for 5 years until his death on November 26, 2008. So medical records established that the underlying cause of his death was brain damage stemming directly from the initial blunt force trauma, no, due to the attack, no, made by the CICL. So in his defense, the CICL denied the allegations against him. He admitted meeting AAA at the barangay hall in Baguio City during the hearing of the complaint filed against him by another person, DDD. However, CICL claimed that he was drinking with his friends at a computer shop in Bonifacio, Baguio City from 7 in the evening up to 12 midnight on October 27, 2003. Thereafter, he and his friends transferred to another bar and stayed there until 4 in the morning of October 28, 2003. He then went home in his own barangay. CICL admitted that he was only a student at that time and he quit school when the case was filed and returned home to Sagada to work. So technically, ang depensa niya rito, denial and alibi. Alibi kasi wala siya dun sa place of incident at nasa kasama raw niya yung mga kaibigan niya and they did bar hopping, no, in Baguio City. So one of the issues here was whether or not the CICL acted with discernment to be held criminally liable. So in this case, the Supreme Court first defined the term discernment. According to the court, discernment is defined as the capacity of the child at the time of the commission of the offense to understand the difference between right and wrong and the consequences of the wrongful act. So the question now is, how do you determine discernment? So the court explained. The court consistently held for more than 100 years that in determining discernment, Courts shall consider the totality of facts and circumstances in each case. Further, discernment may be established by either direct or circumstantial evidence. These circumstances include, excuse me, but are not limited to: number one, the very appearance, the very attitude, the very comportment and behavior of the minor, not only before and during the commission of the act, but also after and even during trial. Number two, the gruesome nature of the crime. Number three, the minor's cunning and shrewdness. Number four, the utterances of the minor. Number five, his overt acts before, during, and after the commission of the crime. Number six, the nature of the weapon used. Number seven, his attempt to silence a witness. And number eight, his disposal of evidence or his hiding the corpus delicti. So those are the things that you need to remember on how to determine discernment. Next question: who determines discernment? But under Republic Act number 9344, Section 22, as amended by Republic Act 10630, Section 7 mandates the social worker to conduct an initial assessment to determine whether the child acted with discernment. So, assessment. No? Section 10 of the 2019 Supreme Court revised rule on children in conflict with the law now categorically provides: as to Section 10, determination of discernment, discernment is preliminary determined by a social worker and finally by the court. So that answers the question. No? Preliminarily determined by a social worker and finally by the court. So the court held there is no question that the social worker only renders a preliminary or initial assessment on the existence of discernment. The assessment of a social worker or psychologist is merely evidentiary and is not binding upon the court. Ultimately, the court finally determines discernment based on its own appreciation of all the facts and circumstances in each case. So, in this case, let us apply the rules discussed. The court held that the CICL here, in our present case, acted with discernment. And here are the reasons. Number one, the gruesome nature of the attack committed against the victim indicates discernment on the part of CICL. Okay? When he mauled the victim with a blunt object which is hard enough to break a skull or shake a brain. Number two, the circumstances showed CICL XXX cunning and shrewdness. He perpetrated the attack early in the morning at around 3 a.m. Imagine that, 3 a.m., while accompanied by a companion. They waited for the victim to get home, and after striking the victim, they escaped before any witness could see them. Number three, CICL XXX attack against the victim can be considered as an attempt to silence the latter or an act of retaliation for testifying against him in a separate mauling incident during the barangay proceedings. According to the prosecution, on October 27, 2003, or a day before the attack, the victim testified against CICL XXX during a hearing on the complaint for physical injuries filed by DDD. The victim allegedly saw him hit DDD with a bucket inside a bar in Baguio City. 4. CICL XXX testified that he quit school when the instant case was filed. He then fled to his home in Sagada for where he worked there. No? CICL XXX overt acts of quitting school and returning home to Sagada are indicative of his awareness that what he did was wrong. CICL XXX's own testimony reveals his awareness that his actions were wrong. So he dropped out of school because he was scared after he received a warning that he should watch his back. To suddenly quit school and flee to his home shows that CICL XXX had full knowledge of the gravity and consequences of his act. And lastly, the records bear that at or near the time of the incident, CICL XXX was a second year nursing student. So his level of education shows that he had the capacity to discern that inflicting body harm upon AAA was wrong and it would likely result to his death. So the court held ultimately a careful consideration of all facts and circumstances, particularly the gruesome nature of the attack, the chosen time and place, the attempt to silence the victim who previously acted as a witness, and his very behavior and level of education indicates that he acted with discernment. As gleaned from these facts, he committed the crime of an understanding of his depravity and consequences. Thus, CICL XXX is criminally liable for his act. So finally, in this case, the court laid down the guidelines on determining discernment. So this should be your takeaway. If you are reviewing for the bar, you should know this. Number one, discernment is the capacity of the child at the time of the commission of the offense to understand the difference between right and wrong and the consequences of the wrongful act. Number two, the task of ascertaining discernment is undertaken preliminarily by a social worker and finally by the court. The determination of discernment shall take into account the ability of a child to understand the moral and psychological components of a criminal responsibility and the consequences of the wrongful act, and whether a child can be held responsible for essentially antisocial behavior. The assessment of a social worker is merely evidentiary and is not binding upon the court. Ultimately, the court finally determines discernment based on its own appreciation of all the facts and circumstances in each case. Number three, there is no presumption that a minor acts with discernment. The prosecution must specifically prove as a separate circumstance that the alleged crime was committed with discernment. For a minor at such age to be criminally liable, the prosecution is burdened to prove beyond reasonable doubt by direct or circumstantial evidence that the CICL acted with discernment. And number four, in determining discernment, courts shall consider the totality of facts and circumstances in each case. Such circumstances include, but are not limited to, number one, the very appearance, the very attitude, the very comportment and behavior of said minor, not only before and during the commission of the act, but also after and even during trial. Number two, the gruesome nature of the crime. Number three, the minor's cunning and shrewdness. Number four, the utterances of the minor. Number five, his overt acts before, during, and after the commission of the crime. Number six, the nature of the weapon used. Number seven, his attempt to silence a witness. And number eight, his disposal of evidence or his hiding the corpus delicti. So here, the court ruled that the CICL acted with discernment, thus he was found guilty of the crime. Thank you very much for listening to my last time I checked 67 subscribers. Thank you. I hope you can for those who have not subscribed yet, please subscribe so that we can post more videos, longer videos, and discuss more concepts about criminal law in this channel. Okay, thank you for listening and see you on the next episode.